Thanks everyone for having me today. As background, I'm Paul Squire, a shareholder here at Polsinelli, based here in New York City. Georgetown law grad, have been practicing for 30 years. Have been in private practice, but one of the features of my resume is that I was general counsel at Teladoc back in the early teens, and was very instrumental in their startup in navigating the regulatory environment they were dealing with. So been back in private practice and have really sort of expanded. And I'd like to spend some time to talk about digital health startups and the regulatory issues that investors should be aware of as they're looking at it. Digital health has been around. It's not the latest thing, but it's definitely been something that's been growing and increasing, and had the pandemic really had some really impacted, et cetera. So Marty, can you go to, I think, slide 3? Go through mine.
As soon as I figure out how to make this work. There we go, slide 2.
We're still on.
Is this it?
Yeah, that's
Digital?
me, right? Keep going. That's it.
It has to go through Zoom for it to go over there. So.
Okay. So before I get into a discussion of the regulatory issues, I'd like to talk about what exactly is digital health. So the Food and Drug Administration back in 2016 did an analysis of digital health before everything exploded with the pandemic, and had some stringent observations about it. Specifically, digital health they saw as facilitating better informed decisions about patients' health, allowing new options for facilitating prevention, early diagnosis of life-threatening diseases, management of chronic conditions outside of traditional care settings. Digital health could assist in diagnosis, treatment, storing and sharing medical records, and enabling a more efficient clinical practice. Back in 2016, the FDA even recognized that it could help in addressing public health crises. Ultimately, digital health is the nexus between healthcare and the internet. Since 2016, investments in digital health have exploded. Pierce Healthcare observed that in 2021, over $29 billion in investments occurred here in the US across 729 deals. 2022 is anticipated to be another record-breaking year for investments. With that in mind, though, next page, Marty. I'd like to talk about a bit of the regulatory challenges. I'm seeing a number of investors around the table and on the phone and on Zoom. And when looking at digital health companies, investors who are not aware of healthcare regulatory issues should be made aware of, be forewarned of the significant regulatory issues that address it. Non-healthcare investors who view a digital health startup as interchangeable with an Uber or a Facebook are really to be forewarned. There are significant federal and state healthcare laws that impact the delivery of the healthcare, how the model is used, how it's monetized. Ultimately, failure to recognize these compliance issues could result in adverse impact on valuation of the digital health companies. So, caveat emptor, it's very significant to understand what the regulatory issues as investors look at potential investments in these companies.
Next slide.
Next slide, please. The first, just as background, this is a US focus. We're US lawyers. This is an analysis focused on US law issues, both at the federal and the state level. The first law that comes into play is the Stark Law, a statute that dates from the 70s. Pete Stark was a congressman from California, and it deals with the relationship between practicing physicians and quote unquote delivery of digital designated health services. Those are listed in detail in the slide: clinical labs, physical therapy, DME, home health care services, et cetera. It is the relationship between a referring physician and these services which come into play into Stark law. One other aspect about the Stark law, since it is a federal statute, it is implicated only to the extent there is Medicare or Medicaid reimbursement. So that is a gating issue when looking at a digital health company. Is there federal monies involved that bring it within the purview and the purview of the federal statute? Next slide. So do you have a DHS? Do you have a digital designated health services? I have a significant client. They deal with virtual physical therapy. DHS, Stark law is an issue we constantly deal with all the time because of the fact that to what extent is the referral implicating DHS such that we could be in violation of the Stark law. To the extent you have a DHS designated health services, you need to undergo an analysis of whether or not there is a financial relationship. And that financial relationship can be an ownership interest where the physicians, et cetera, have an interest in the DHS provider, or is there a compensation or financial arrangement between the referring physician and the provider of the DH services. Those are very broad definitions, and the definition of compensation is so broad that ultimately it becomes an issue of whether or not this is going to be subject to Stark. Moreover, who is designated as the physician because of attribution rules can capture issues such as in-laws, family members, parents, children, divorcees, grandchildren. So the purview and the remit of the statute is so broad that Stark can be implicated, et cetera, even whether or not it's not a direct relationship. So does Stark law after this analysis apply? If it does, and in likelihood for my client that deals with physical therapy, where it does all the time, we have to work constructively with the investors as to what extent we can avail ourselves of a safe harbor, which by falling within the definition of the safe harbor permits the relationship to be approved de novo without regulatory review of not running afoul of Stark. One of the issues, the unique feature of the Stark law is even when you may not have an intent for referral or a violation, there is no quote unquote scienter requirement. So, but for the fact that you have a relationship where you're referring to another provider for DHS services, you have a Stark law violation. So regulatory attorneys have to deal with this issue all the time, and we're always trying to fall within some designated safe harbor. The one that comes to mind, they're not listed here, the one that comes to mind and is usually avail themselves is the in-office ancillary services. To the extent that the PT services are provided within the same practice of the referring physician, there is an exemption, a safe harbor, which will allow it to be permitted. Next slide, Morgan. AKS, anti-kickback statutes. Again, at the federal level, we have a determination of remit, whether or not this applies. If there are Medicare or Medicaid funds being paid to the provider, federal AKS is implicated. In this instance, AKS has a somewhat narrower focus in that there is no intent. There's an intent requirement, so you can't have a violation in and of itself merely by the relationship. However, the definition of AKS and kickback is fairly broad, such that it is unlawful to knowingly and willfully solicit or receive any remuneration, either return referring to an individual for a service, or for purchasing, leasing, ordering, arranging for any item or service. Under the definition of anti-kickback, to just give you a sense of how broad this is defined, that remuneration need not be an actual physical payment. Under a narrow definition of what constitutes, a broad definition of what constitutes an AKS, a referral between two different independent physicians could be viewed as an anti-kickback violation. So we have this other issue of trying to avoid relationships that may apprise or require, to what extent this could implicate the AKS. What happens a number of times, especially when I'm dealing with my clients, is AKS is implicated. We have Medicare, Medicaid funds, we have a referral relationship, there are payments going back and forth. We try to make avail ourselves of some safe harbor that's available, et cetera. A recent safe harbor that's become very popular is what's called the care coordination safe harbor, where two practices that are referring back and forth between a specialty practice to a general practice. There is a care coordination committee that determines where care is being provided for the best results. There's data collected concerning outcomes and results, that there's better care as a consequence of it, and do that. That is a fairly recent safe harbor. Care coordination came in 2020 and has become very popular. Next. The prohibition on the corporate practice of medicine. So this is no longer a federal law issue. This now becomes a state law issue. And this is not a state law issue in all US states. Approximately half the states in the United States have some version of the corporate practice of medicine prohibition. California, Texas, New York, New Jersey, Michigan, Massachusetts, significant population centers have a version of this. The one place where this doesn't apply, which is viewed as the Wild West, is Florida. You can do whatever you want, anything you want, never have an issue. I have a number of clients who operate nationally, and as a consequence of this state-by-state prohibition, my clients just take the approach and my advice to just operate as if CPOM operates in all 50 states. So we use professional entities in Florida, we use professional entities in Missouri, in order to just ease of operation. What exactly is the prohibition on the corporate practice of medicine? Fairly simple concept. It prohibits the employment or use of physicians by a business corporation. So in order for clinical services, for determination of clinical physician services to be provided, subject to minor exceptions, that physician needs to be employed by a professional corporation owned by individuals licensed in that same profession. So here in New York, a psychologist can only work for a psychology practice. It cannot work for a psychiatry practice. You have nurse practitioners who can work for medical practices, but a doctor can't work for a nurse practitioner in a practice owned by a nurse practitioner. And on it goes. Wow. So you have this concept. It continues to have some validity. There was enforcement actions in New York back several years ago. The state attorney general had enforcement action against a national company called Aspen Dental, where a consent decree was entered into over a number of issues, one of which was corporate practice. So in order to arrange or sort of deal with CPOM issues, you will find the use of what's called a MSO model, Management Services Organization. So for example, Teladoc, a publicly traded company on the New York Stock Exchange, has an MSO model. The entity that trades on the stock exchange is the MSO. It then has relationships with a number of professional entities throughout the United States that actually provide clinical services. So when you talk to a Teladoc doctor, you're talking to a doctor that's employed by a New York professional corporation, a Texas PA, a California professional corporation. But the structure is such that the management company, the company that collects administrative fees and arrangement for the services, has the lion's share, basically 100% of the revenue out of these friendly PC arrangements. So, a determination when you're looking at your digital health companies is there clinical services being provided? And if there is, there probably will be need to set up a professional corporation in the states where you're, practicing to ensure that you comply with CPOM requirements.
About 10 minutes.
Okay. Next area of focus is the unlicensed practice of professional services. So this can become an issue, especially in the telemedicine space, where a doctor is sitting, a clinician is sitting in one state and is treating a patient in another state. It could be as simple as someone sitting in New Jersey treating someone here in New York. You could have a retired physician in Florida who keeps their license in Illinois and wants to continue to practice there. How does this rule apply? Well, the state medical boards, of which physicians are subject, have taken the position that they don't really care where the physician is located. It is driven by where the patient is. So if the patient is located in Chicago, that doctor who's treating that patient needs to be licensed by the state professional organization in Illinois. That is a rule of thumb that can be applied on a state-by-state basis. But this is a very critical issue, and it gets muddled a great deal by individuals and investors who believe that where the physician is located determines where licensure is required. Doesn't have any other issues. Marty?
So there's been an explosion in like these online psychiatric and wellness care, companies. I mean, I probably had a dozen come to me in the last 2 years, right?
Right.
And they're like, oh yeah, we're using therapists that are in Tennessee to counsel New Yorkers. There's a big demand, et cetera. And so, I guess all those therapists have to be licensed in New York
Correct.
to be able to provide the service.
To the extent they're providing a clinical service. One of the things these
I
companies
think they call it counseling.
Right, that's sort of the key issue. And you can thread your needle through this. There are companies, and some of them are my clients, who take the position that they are not providing a clinical service. So that goes back to, do we have a clinical service here? You may hear the term coaching. Coaching is a real big term. So coaching services are not regulated in any state. You can provide coaching services, support services that don't require licensure. The key is how you define coaching. Coaching, by definition, has to be non-clinical. So you can encourage people, you can support, I'm having a really bad breakup and have suggestions on how to deal with it. But that coach cannot in any respect say, oh, you have clinical depression and you need to do A, B, and C. That, by definition, is a diagnosis. And by diagnosis, you can now become a clinician and therefore need to be licensed.
So nothing diagnostic.
Correct.
Right.
So as an investor, you are basically on the hook for the people that you're recruiting as physicians because let me explain my thesis.
Okay.
And the consumer can come back and allegate that they received a diagnosis. And if they do at any given point and they are harmed or they want to claim something, they can very well come back at you.
Oh, yeah, they're definitely liability.
From the consumer, yeah.
Right.
It's a big liability from this.
So Carlos said, where I try to guide my clients on this is you have to have very specific protocols on what can and cannot be done by the counselor in your instance. There should be a record of what's being.
It's always recorded for sure.
See, I'm not convinced that recording
Maybe
is
they can't, yeah.
right.
Maybe.
I'm not a big fan of recording.
Maybe the company can't, but the customer can. Because when you're doing coaching, for instance, people that get coached, they like recording it because you can't get the most of a conversation you're having with your coach. Now, if you come back to the coaching session and listen to it 2, 3, 4 times, now you're picking up everything. When you first told something, you try to react about it, and you don't really sink it in and analyze what you're getting told. You're thinking what you're going to respond. Now, when you listen to it again, now you're like picking up on what they're really
Why
telling
would
you.
there just be a follow-up coaching session where we sort of?
No, there always are.
Right.
I mean, like, that's
Right.
the whole business.
Right.
So part of the Obamacare Act was that if the physician does follow up the patient, they get paid extra for doing that. And I think it's something around $2,000 a year. There's actually a company out in Southern California that has kind of systematized it. So what they do is they approach physicians to do follow-up with their patients, right? They have a bunch of nurses in the Philippines, and they do follow-up via text message or email, right?
So
But it's not diagnostic, it's follow-up, right? And then the company splits the proceeds because it's found money, right? The physician would never do the follow-up and never file, but they do the follow-up, they do the filing, they collect the money, and then they split half and half with the physician. Right?
So, but Marty, we're dealing in a focus where someone is discharged from a hospital or like.
Oh, just the patient visit, yeah. Like if you take all your antibiotics for 10 days.
That typically was done by the nurse in the office and.
Yeah, if it was done right.
Right. Yeah, no, I mean, the issue that comes up is what they're doing clinical?
No, it's really intriguing.
And
right?
if it is clinical, is it being done at least under supervision of a licensed physician?
So what's interesting about it is that so they have all these Filipino nurses, and then there's an American nurse practitioner over all of them. And I think a nurse practitioner does all the signatory and other stuff like that.
The licensed physician, the licensed nurse signs on the note.
Exactly right.
And as a consequence of that, yeah, we looked at that as a firm for another significant client as to what you have to be very careful because they start to bleed into each other. So in what I've seen before is that intake. So you can automate that. You can have the nurse based in the Philippines who converses in English, can do everything, probably has a clinical background, but can't use that for that.
It's just follow-up, and they make you aware that if something is amiss.
Well, there's also the intake. There's an intake process. You're sort of collecting information. So to the extent it's administrative, you can offshore it in any respect. But it's when it starts to bleed into a clinical aspect to it.
Right, that was my next question, is what happens if all this stuff becomes, digital autonomous organizations where they're kind of just like collecting the intake, right? But there's no human behind it all.
There needs to be at some point.
Interesting. Okay.
Yeah, I have one separate comment after just about the healthcare practice overall, but please finish.
Yeah, so we talked about, so we'll go to the next one, unfair trade practices. My favorite, because this is really sort of the catch-all that no one's aware of, and it gets used all the time at the state level. So there is a template Unfair Trade Practices Act that's been adopted basically in every state in the United States. And it deals with, and it gives power to state attorney generals or departments of consumer protection to regulate and fine, unfair trade practices, which can consist of, basically deceiving consumers in some respects through copy, through marketing, through services, et cetera. So it's misleading. It's aims to focus on misleading representations. I'm currently dealing in Connecticut with a regulatory issue where totally separate. It's a regulated provider, have their issues. The department threw at us, oh, well, this is an Unfair Trade Practices Act. I'm like, what? How does that relate to the provision of clinical services? And they were going to drive a truck through this. And so everyone should be aware that this is always lurking around as the ability to do this. The enforcement against Aspen Dental backed by the New York Attorney General was based upon, in part, Unfair Trade Practices Act. There is there was an enforcement back in 2017 on the digital health companies. There were companies that were using Fitbit type services and representing, well, we can track your heartbeat and things like that. The New York AG at the time, Snyderman, said, no, 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 that's misleading. Slapped them on the wrist, $30,000, et cetera. So this is another area that investors should be aware of, and it's focused on what the digital health company is promoting and is claiming as their own. And it has to be accurate. I mean, it does has to be accurate, and it cannot be viewed as, if it hasn't been approved by the FDA for its intended purposes, if it's any type of medical device, then you can't represent that it doesn't. So.
So my general comment is we have a very large healthcare practice, represent very large hospital systems, nursing homes, and it's one of the biggest areas. Out of 950 attorneys, we probably have several hundred just doing that. I wanted to mention one deal very generally that Paul has helped me with, where we're actually representing a doctor that owns several clinics in New York, and I'll keep it general, in New Jersey, and they're getting an investment in. Pretty basic deal, what I've seen, but because of the healthcare issues, it's been somewhat of a challenge, let's just say, between all the different things. So Paul is handling that. We've had to bring in the corporate team to do some restructuring. We have the tax team looking at all these things. So what I thought was initially an investment, a straight investment, is much more complex because you're dealing with healthcare in New York City, and there is just a myriad of issues that must be challenging when you start getting into the millions and hundreds of millions. That's why the group is so big. So
In the deal that Pete refers to, we're setting up an MSO. So we're putting up an MSO to manage the doctor's practices. She needs, there's a need for capital. This is the best way, and we're setting up a similar relationship.
What's really intriguing is that there's a lot of arbitrage opportunities people see in the psychiatric services area, where they
Huge demand.
Right.
Huge
So,
demand.
and I'm going to give you an example, right? So we have a company out of California so the state of California pays $300 a night for these halfway houses per bed.
Yeah.
Right. So this company went and it's approaching every municipality in California and saying, look, give us somebody who hasn't paid their property taxes, give us their real estate, we'll convert it into a halfway house.
Yeah.
Right. And then we'll provide all the medical services you need via telemedicine.
Yeah.
Right. So historically, a halfway house has a psychotherapist who visits once a week, something like that. And then they have a nurse practitioner who visits a couple of days a week. Right. So this guy has organized it to have a nurse practitioner who's there. And then all of the counseling is done remotely. So, and apparently his argument is that schizophrenics actually react better to people on a computer terminal than to people in person.
Yeah.
Right. And so he's arbitraging the whole thing with psychotherapists in Tennessee and Alabama, versus the California practitioners who are charging $500.
So what telemedicine does is the ability to leverage, that halfway house may not necessitate the need for a psychiatrist, 5 days a week. So you have this individual sort of traveling around the LA basin, and all the time, and better just to turn on a computer, have a nurse practitioner be what's called the presenter to make sure the patient's ready and deals with that. And then they deal with it.
So his arbitrage, he's crushed the pricing down to $110 a night per bed, and he's charging the municipalities in the state $180 a night. Right, so it's a tremendous arbitrage just because he got rid of the whole, psychotherapy, and all these people who are in Alabama, they're licensed in California.
Yep.
They can write prescriptions.
Medical Board of California doesn't care where you are.
Exactly right. So as I said, there's a huge arbitrage that people seem to have really addressed, in particular in the psychotherapy, in the psychopharmacological area, right?
Especially with everything that went on during COVID and all the mental health issues.
Right, there you go.
Right. There are some waivers that I should mention, that there were some waivers on licensure issues that came about during COVID. Most of those, if not all, have now expired. But and states' medical boards are becoming more in focus on it. But as we saw in a number of other industries, the pandemic changed the paradigm, and it's just facilitating changes that were already occurring, and now it's just sort of Yeah, it's really.
It's really fascinating. Yeah.
Yeah, yeah.